Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm the Marketing Manager at Schoeneck King. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to address those as time permits. Once the webinar has ended, if you would take a moment to take the survey, we would appreciate it. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. So it's now my pleasure to introduce today's moderator, Adam Masterleo.
Kathy, thank you so much, and welcome to everybody who is joining us this afternoon. As you all probably know, between last week's Tuesday webinar and today, we put on a webinar dealing with the HERO Act activation and what that means for employers. We received so much interest and so many questions from that webinar that we are going to cover some additional FAQs during today's webinar that we've been hearing from clients, and also that cover some of the FAQs the state put out. We also are going to talk today about the various vaccine mandates that have been coming out, including the president's announcement at the end of last week. So we have a packed program for you this morning. And so that I don't take up any more time, let's get right into it. Stephanie Fedorka and Andy Bobrick from our Syracuse office, who have presented on this issue already a number of times, are going to cover the HERO Act FAQ. So please take it away.
Thanks, Adam. Good to be with you. Good to be with everyone today. Yes, so I guess the key topic for so many of our clients and firm friends is the HERO Act and activation. We did do a standalone webinar. Adam did that along with Stephanie Fedorka, who's on and will be presenting today too. It was a great webinar that covered a lot of helpful information. That webinar was recorded and is available on our website, so you can access it through the bsk.com website. If you need a specific link, let us know. We can connect you with it. And those slides are available as well. So I don't want to belabor too much the introduction. I think everyone knows the basics here, but just to reiterate quickly, we're going to be focusing on the piece of the legislation that dealt with the airborne infectious disease plans and programs, not the other piece that it deals with the workplace safety committees. We'll be covering that in the weeks ahead. But for now, that legislation, that piece of legislation is not yet effective. Just a couple other preliminary points here that you'll see on the next slide. So just some key dates here. Again, you know all this, I think, at this point. The key date that we're really dealing with now is the September 6th date. That's the date when the State Department of Health designated the current conditions that then trigger activation of your HERO Act plan. Of course, that plan was supposed to have already been adopted earlier this year and disseminated to employees. If for some reason you haven't done that yet, you're likely not alone in there. I know there was a lot going on at the time. Encourage you to work with us or your favorite bond attorney. We can work with compliance and get that rolled out with you as soon as possible. Just some background too. I don't want to go into a lot of detail on this, but we did want to include the slides. And we will provide these slides to all attendees afterwards too. What does activation mean, right? What's required by activation? In here on the next two slides, this is just a list of what needs to take place under the legislation once that activation occurs. Again, we think most here in attendance are at the phase where you're in the midst of the activation and questions are now coming up that aren't necessarily answered in the statute or in the guidance that the state put out. And again, that guidance came out late last week too. The person here at our firm at Bond, who has been most closely following these issues, and for those of you who attend these webinars and read our blog entries, know it's Stephanie Fedorka. Stephanie should be commended for doing such a great job of tracking this for the likes of me and others here at the firm, as well as for our clients. And she and I are going to go through some of the FAQs that we've identified. In about a second, I'm going to push out a link to an article that we published late last Friday. We wanted to get it out to you so you might have a chance to read it over the weekend. If you didn't, I'll push out that link so you can see it. But that contains an article that really gives a bit more detail on the FAQs that we've identified. Again, we'll go through some of the key ones today and discuss them a little bit, but please continue to fire your questions toward us. We're not going to be able to answer them all today, but it's very helpful. You pose great questions, and it helps us identify what the patterns are and consistent questions that clients have so that we can address them in the future. I'm sure we'll be talking about the HERO Act again next week, and perhaps even in the interim as situations may change. So with that, why don't we turn next to the FAQs? For these, Stephanie, welcome. Great to have you again. Sorry about the bills this weekend. That was a tough one. We commiserate consistently, Stephanie and I, but fortunately last year we got to celebrate a little bit too. It was nice for a change, but I guess we're back to commiserating, huh?
Yeah, I guess so. I mean, I hate to jinx it, but maybe it was fans not being in the stands that really did it for us last year. But
Can't possibly be that. No, yeah.
Thank you for your kind
Sure.
words. It's been great to follow this and give updates to our clients. So without further ado, we'll jump in. So for our first question, when do we need to activate our plans by? There is no specific deadline in either the statute, the standard, the guidance, or the model plans, but what we do know is it needs to be activated promptly. So time is of the essence. I think the sooner that you can get these finalized, activated, conduct your verbal reviews, etc., the better. Second question, must healthcare industries adopt a plan? If you recall, the standard had specifically provided that health or employees who are covered by an OSHA standard would be covered by an OSHA standard, and the New York HERO Act standard would not apply. So right now we have the OSHA emergency temporary standard that only applies to healthcare settings. So the answer is maybe. It's quite possible that you have a workforce where you have some employees that are subject and covered by the OSHA emergency temporary standard, the ETS, and you may have other employees who are not. So generally speaking, if you have OSHA employees that are covered by the OSHA ETS, the ETS applies. If they are not covered by the ETS, and there are certain technical exceptions and exemptions from that ETS, then the HERO Act would apply. So if you have questions or concerns about whether or not you are in one of those hybrid-y situations where you're not sure if you have to adopt a plan or follow the New York HERO Act plan at this time, please feel free to reach out to your favorite bond attorney. It can take some technical analysis to figure out exactly if you fall into one of those OSHA ETS exemptions or not. Oh, go ahead. Sorry, Andy.
No, that's okay. I think you covered it very nicely there. I think I see some confusion on this issue from attendees and even some clients who we've worked with. And again, correct me if I'm wrong, but I think that confusion arises from the notion that the ETS covers, from OSHA covers healthcare, and rather it does in a sense, but in terms of who specifically the standard covers, it's certain healthcare employees, correct?
Right, and the way the OSHA ETS works is it depends and it's contingent upon where healthcare services or healthcare support services are provided. And then there are technical exemptions. For example, if you have an administrative building that is completely off-site from, say, a hospital or another facility where you are providing those healthcare services, which carries its own definition under the OSHA ETS, then those employees may fall within that exemption and they would not be covered, arguably, by the OSHA ETS.
Okay.
It is a very technical, depending again on what your operations are. And I know that certain parts of certain exemptions under the OSHA ETS also depend on whether your employees are vaccinated or not, or you're exempting or you're restricting individuals who may be positive for COVID-19. So it's not a blanket, all healthcare industries are covered by the OSHA ETS or not. It is very technical. So
great. That's helpful. Thank you for clarifying that.
So on to the third question, do public employers have to adopt a plan? It is very clear from the definition in the statute that public employers, government employers are exempted. They are not part of the definition of employers. So this does not apply to you if you happen to be a public employer. Next slide, please. I think Andy, handing it off to you.
Great, thank you. All right, so does it matter how many employees this has? Again, the answer is no here, it doesn't. If you're a covered entity in the private sector, there is an exception. If you're a sole proprietor with no employees, then there could be an exemption there. I guess the operative principle being there's no concern about cross-contamination among staff. When do we have to conduct our verbal review? Well, again, the guidance that we got from the state provided some insight there, and kind of reading between some of the lines that are there, we of course had advised as a precaution and a recommended best practice to conduct this when we adopted it earlier by the deadline. The guidance also indicates that we should conduct this verbal review after the designation and quote unquote activation of our plan. Well, okay, what does verbal review mean? That's probably the most frequent question that I've gotten. Of course, I went right to Webster's and looked up verbal, and verbal means very simply with words. And extrapolating that principle, it could stand to reason that you could do this communication in writing. However, and I think that's still a point to consider, and ultimately it's going to depend on your comfort level and the particular circumstances and facts in your case. The model plans, however, use the term training, we think interchangeably, and that was the intent there, was this training was referencing the verbal review. And quite clearly that guidance envisions a more traditional training setting. The guidance that the State Department of Labor pushed out late last week also echoes that. And although it doesn't rule out employers from providing the verbal review in writing or through some comparable means, it seems to contemplate it being presented in a more typical training. Although it doesn't have to be a live session, it could be a recorded program or a virtual or web-based type of program there too. So my advice on the verbal review issue is work with your bond attorney, talk to them, identify a plan and process that makes sense, that you're comfortable with the advice of legal counsel. Stephanie, I think we're going to move on and have you handle the next batch.
Great. So what about independent contractors? Does my plan apply to them? And the answer is yes, to a certain degree. The definition of employees, as we've mentioned before, is very broad under this law. It does cover independent contractors and other contingent workers, employees who might be working for staffing agencies, et cetera, who are engaged at your workplace. The guidance also that came out last week says that you have to provide a written copy of the plan. It clearly states you have to provide a written copy of the plan to independent contractors. But other aspects of the plan do not apply. For example, the training requirement or the verbal review requirement that we were just talking about. It's very clear that you do not have to provide that to your independent contractors or other contingent workers. But making sure that they are also complying with the plan, et cetera, and the expectations in the workplace, and providing them with a copy, those aspects certainly will apply to them. Next slide, please.
All right, this is probably the number 2 question, maybe number 1 for some. What about health screenings? Do we have to do these again? And if we have to do them, what should they entail? I think our best read is that based on the statute, reading of the statute, and as supported by the guidance that the state has put out, that indeed screening is required at this point. What that screening should entail, however, is an open question right now. What's stated in the law is that the screening must be performed in accordance with any state or CDC guidance. And we have no such guidance currently in effect and in place right now, with what was out previously having been archived for the time being. So it does raise the question of what type of screening should be done here. That is going to be something you're going to want to talk with your bond attorney. And again, get to a place where you're comfortable from a practical and legal standpoint. It could entail several different approaches. One approach that we've discussed with a number of clients, admittedly, I think a conservative approach, but one that some clients have adopted, is to follow the screening process that was utilized under the state's New York Forward programs and the guidance that was put out at those times. But again, there could be alternative options that may make sense and work, and you're going to want to get counsel to make sure you're comfortable with those approaches. We've worked with a number of clients on that front already. All right,
Andy,
yes.
Andy, I'm going to interrupt you here for just a second, because we got a question that I think you'll be able to address relating specifically to the screenings.
Sure.
Do screenings apply to all employees or only those who are unvaccinated?
I believe they apply to all employees. I'm not aware of any exception for vaccinated employees, but that's a good question. I guess just as that jogged my memory to another question we'll get. During the New York Forward, we had to keep track of visitors too, and we had to screen visitors. And the New York Hero Act does not require the screening of visitors. That may be something you want to do. It may be something that officials tell us we have to do at some point in the future, but as of right now, that is not part of the screening that is required under the Hero Act. So many of you may have multiple operations and multiple different offices, multiple different locations, differing operations, and that leads to the question of, all right, well, must we have a separate plan for each area? And the short answer here is not necessarily. It could be, given your particular operations and industry, that one plan will be sufficient to cover all of your different operations and work sites. And again, the statute uses the term work site, and there's a definition for that. So not necessarily, but if you do have differing operations, it could well be that you need to adopt different types of protocols and controls in place that track with the industry-specific state model plans that are out too. That's an issue, again, not to sound like a broken record, but you want to get comfortable, recommend you seek legal counsel and work with your bond attorney on that. Do I have to put a copy of the plan in my employee handbook? Quite clearly, we think the answer definitively is yes, based on a reading of the statute itself. Now, this seemed somewhat, I'm trying to think of a nice way to put it, confusing, let's say, when the statute first came out and we had to adopt these plans and publish them in our employee handbook, because at the time we were talking about a draft plan that's not activated, that's incomplete. But this makes more sense now that the plans have been adopted, communicated, and now are required to be activated. So the answer there is yes. Stephanie, how about the next batch?
Working our way through these, right? What if I don't adopt a model plan? So as you may recall, there were two options that the statute provided you with. You could either adopt one of these model templates that the New York State Department of Labor pushed out back in July. If you don't adopt a model plan, the statute does allow you to adopt an alternative plan. However, you have to meet the additional criteria if you're going to adopt an alternative plan. And that includes that the plan be tailored and specific to the hazards in the industry and work sites. And if you are in a non-unionized setting, it requires meaningful participation from employees. Or if you are in a unionized setting, then it requires agreement from the employee union or the collective bargaining representative. So just a couple of extra hurdles if you are not just going to adopt the model plan and plug in those open fields that they have open for you. For example, the administrative controls section or the engineering control section, et cetera. Which nicely away into our next question, what constitutes an alternative plan? And it's not, we don't have a ton of guidance. However, the guidance that was issued last week suggests that making any substantial changes beyond those open fields. So if you make changes to the sections that allow you, it provides a list of examples and allows you to select which administrative or engineering controls, et cetera, you are going to implement or you plan to implement in those open fields. Anything beyond that, it seems the Department of Labor seems to be taking the position that they will find those to be an alternative plan and therefore trigger those additional criteria. Next slide, please.
All right, so if we're in the situation where we've evaluated the circumstances and determined that we've adopted an alternate plan and we're in a non-union setting, what does the meaningful participation from employees mean? That's not defined in the statute, and here we're taking a look at the guidance and trying to interpret it. Really, from a base level, what we're able to glean is that employees should have an opportunity to review and comment. That makes sense to me. I think that's a pretty basic notion, a pretty basic element. I don't think this means that you have to have a committee formed and the employee committee has to approve the plan. I don't think that's it at all. I think an opportunity to review and comment on that. And frankly, that could be accomplished in a fairly simple and fairly straightforward way. It'll depend on how your workforce is made up, how matters like this are communicated to them. But certainly, for example, in an office setting, it could be as easily as disseminating the plan by email to employees and affording them the opportunity to offer any comment on that. And ideally, as an employer, you want to be able to take that commentary into consideration and perhaps make any changes to your plan that make sense upon your further review of that. So I think, Adam, that's what we got for you in terms of FAQs. I'm eager to look at the questions that we got from our audience because I know they're going to have good ones there. I don't know if you have anything else you'd like us to take a crack at here. I know we have some other great content to present too.
So no, I don't right now. That was awesome. Thank you so much, Andy and Stephanie. For those of you who are wondering, I know we're going to get this question. We will definitely provide a link to this presentation. I think it'll be available tomorrow as they usually are. So please, feel free to rewatch if you have questions. And if you have anything more specific, reach out to myself, Stephanie, or Andy at any time. All right. So next up, the other very significant and important issue of the moment are vaccine mandates. We've seen a number of mandates put in place by governmental entities, including an announcement from the President of the United States late last week. So here to discuss those is Hermes Fernandez. You all know Hermes by now, and we're pleased to have him. So Hermes, please take it away.
Thanks, Adam. Kathy, I hope you're, there we go, running the slides. Thank you. I'm really going to be doing this at a 10,000-foot overview because there is a lot to discuss in a very short amount of time. A couple of things I do want to point out, you'll see, is there are a number of mandates there. So I've been on a number of calls. In fact, I was on a call this morning with other lawyers through the Bar Association's Health Law Committee. And we were having quite a bit of discussion among attorneys about what was happening with their various clients and how they were dealing with this. And so I think a large part of this context is just to realize that there are a significant number of mandates that are out there. These mandates are not, right, are not the suggestion of everyone lines up, gets the shots. This is really mandates that are about people do have a choice. They may not like their choices, but they have choices. So let me go through first. I'd identified three mandates as the big three at this point. That doesn't mean there won't be others coming, and it doesn't mean that something may not be more important to you and yours than these particular ones. But the first one is the State Department of Health mandate for healthcare workers. The second is the mandate that President Biden announced. That's the rule for employers of 100 or more. A mandate for the workforce is there. That is coming out under the Occupational Safety and Health Administration rule. And then there's a presidential executive order for federal contractors. Next slide, please, Kathy. Okay, so we've got other mandates. There is a federal employee mandate in place, right? So that covers federal employees. The State University of New York has put a mandate in place for students who are attending in person. New York State has an employee for its, a mandate for its employees. New York City has a mandate for its employees. The New York City Department of Education has a mandate in place for its employees. And I'm sure as we go throughout the state, there are school districts that have mandates of one sort or another. And these are all vaccination mandates. These are not mask mandates I'm referencing. The mask rules are separate and apart. New York City has put in place mandates for indoor dining, for indoor entertainment. But we've seen that in lots of places, right? The Carrier Dome has a requirement now for entrance if you have to have a vaccine or show a negative test within a week. I believe the Buffalo Bills had something similar. Those are throughout the state. Let's go to the next slide. So let's start with the New York State DOH mandate for healthcare workers. I start here for the very simple reason that I know not all of you on this call are healthcare employees, but this mandate is actually in place. Some of the others that we'll be talking about are still to come. And we've gotten quite a few questions about this. So this is an emergency rule of the State Department of Health issued through its regulatory processes. It's in place for 90 days from its effective date. The effective date actually was August 27th, last month. We'll see where we are in the COVID scheme of things, but I would expect that this emergency regulation will be reissued more than once. It applies to hospitals, nursing homes, certified home health agencies, licensed home care service agencies, long-term home health care programs, AIDS home care programs, hospice, and adult care facilities. All of those are defined terms. If you are not one of those defined terms, this rule doesn't cover you unless you somehow come within an umbrella of a hospital or a nursing home, etc. So we've gotten questions from other providers about physicians' offices, for example. If a physician office is owned and controlled by a hospital or hospital system, it is going to be, and has an Article 28 license, therefore it's going to be a covered entity. If it is a private practice of medicine, right, so it's the type of practice you once saw, which was not controlled by a hospital or some sort of health system, it is not covered. The only question in my mind is the Consumer-Directed Personal Assistance Program, which is actually quite a large program. It's a type of home care. There is some inconsistency in the regulations, and if people want to talk to me offline about that as to whether they are covered, I'd be happy to do that. But right now, I think that's the only one. I've been surprised, but we don't see coverage at this point for things like services that are delivered under licensees from the Office of Mental Health, or community residences operated by providers under the auspices of the offices for people with developmental disabilities. So there's quite a lot of healthcare that is not included under the mandate, but this is still quite significant. Let's go to the next slide. Again, I've already made the point, if you're not on the list, you're not covered. Who's covered by this? In terms of the employees, it is actually the employees of the covered entities, their contract staff, students, volunteers, and those employees of affiliated entities who come into the covered entity. So let's say, for example, a physician has privileges in a hospital, right? Physician's a member of the medical staff. That physician may have his own practice or her own practice. Once they come into the hospital, they would have to meet the vaccination requirement. Others coming in as well. Anyone who is patient-facing or whose activities could have some impact upon the spread of COVID-19 in a facility is covered. Next slide, please. So what is the actual mandate? The mandate is full vaccination. Now, full vaccination may mean 2 shots. If it's the Pfizer or the Moderna vaccine, it's 1 shot if it's the Johnson & Johnson vaccine. But the regulatory language is specific as to when the first shot must take place. So this regulation has been in place since the end of August. But there's not the true mandate for the first shot, the first vaccination shot is for hospitals and nursing homes by September 27th. For all other covered entities by October 7th. The regulations then essentially presume that the second shot will be delivered on a timely basis. And there are record-keeping requirements in place under the regulations, and there are reporting requirements under these regulations as to who's had the vaccination and when they've gotten the shot and what was delivered. All that needs to be reported. There are exemptions, and this is controversial, but the only exemption under this regulation is a medical exemption. There is no religious exemption under this regulation. And this is not a regulation that provides have a vaccine or be tested. This is a vaccination requirement. The medical exemption, there's actual language in the regulations as to what the exemption must meet. So there are recognized standards at this point in terms of who is medically exempt from the vaccine. A patient's physician, so the employee's physician, can provide the statement of exemption, but the exemption must meet the standard of the regulation. So a physician simply couldn't say, Mary Jones is my patient. I believe that Mary Jones meets should be medically exempt. The exemption has to be met. So the terms of the regulation have to be met. And that again has to be reported. So there's oversight on this. We can see that we know firsthand at this point that there are employers within this realm who are uncomfortable with reviewing these exemptions, but nevertheless, that's the requirement. Let's go to the next slide. So the federal rule, there is no federal rule yet. There is an announcement of a prospective federal rule that applies to large employers. Large employers will be those having 100 or more employees. The Occupational Safety and Health Administration is developing this rule. It is expected in October. It is a rule that will have both a medical exemption and a religious exemption. Now, if you are a New York State healthcare provider, there certainly would be some question as to which rule applies. At this point, without having seen the federal rule, my expectation is the state rule will apply. But until we see what comes from OSHA, I wouldn't say that definitively. The religious exemption, I expect to be somewhat narrow. And by that, I mean, I don't expect someone to simply be able to say, getting the COVID-19 vaccination violates my religious beliefs. I'm expecting this to use language that we certainly have seen in other circumstances that talks about a sincerely held religious belief. And if you're claiming a religious belief as opposed to philosophical belief, it's a belief that actually has to align with some religious entity, right? Not a church of one, but some church that has actually laid out some basis for why an exemption would take place. Now could turn out to be a difficult issue for employers and employees. Let's take just Catholics, for example, right? The Pope has already said that there is not a religious exemption for Catholics. So that I would think will eliminate most folks who claim to be Catholic claiming religious exemptions. Nevertheless, we still would expect to see those who will come forward and say, well, in my view, I still am entitled to this exemption. There's many religions, and we'll see how this plays out, but it does have to be a sincerely held religious exemption. I'm sure the medical exemption, I don't know if it'll use the same language or something similar to what we see in the state rules. I would expect to see at least something similar. And we've seen other, we certainly have seen other examples of this. So this is still to come. We'll see how this plays out. The other pieces, and certainly, Adam and Andrew and others can talk about this, but this is a rule that is not self-enforcing. It's up to OSHA to enforce, which means that employees may call in. And this is going to be an interesting play here, because one of the things about these about the vaccination requirements is we've certainly heard much in the last few weeks about concerns about employees who will refuse to be vaccinated, and will they leave your workforce because of their concerns? Well, at the same point, there are many employees who have been saying, I don't want to come to work. I'm concerned for my safety. And they may have concerns if they see exemptions being granted too easily. Once they've been induced back to work on the ground that vaccinations are in place, those employees may be saying, look, I'm now concerned that my employer is giving out the exemptions too easily and will be making reports themselves. I've certainly heard that sort of thing already with the HERO Act, of employers being concerned that their employees being concerned that their employers are not taking HERO Act concerns sufficiently. So we'll see how these things play out. Let's go to the next slide, please. Now, the other order, and this order is in place, but yet it's not quite in place, is for federal contractors. The president issued an executive order in the last couple of weeks requiring federal contractors to have their workforces vaccinated, but there are exemptions, again, religious and medical exemptions. The language of the order appears to have a broad scope, but it truly is, at least in my view, less than actually meets the eye, because there's a broad definition of contractor, but this executive order only applies to new contracts. So this is not an effort by the president to redo existing contracts. And so it will be contractors with new contracts who will be applying this order. So this is really a go forward. And then there's more to come. Even the executive order then places obligations upon the covered federal agencies to put together standards to apply to their contractors and their contracts. So once again, this is developing. Even the definition of contractor, I think, is developing at this point. The definition of contractor in this executive order is intended to be the same definition of contractor that was put in place in July when the president issued an executive order requiring federal contractors to pay a $15 minimum wage. If your company is covered by that order, you will be covered by this order. If you're not covered by that order, you will not be covered by this order. So there's much here to go through. There's much to digest, and if you fall within this, we will, we'll obviously work with you in making determinations as to how this applies and what applies. But this will have also some variances from agency to agency. It also does not. I should point out this does not apply to federal grant holders. Grant holders are not regarded as contractors, and so many not-for-profits may find themselves not covered by this because they're grant holders, not actually contractors. I believe that is my last slide. So there's a couple of other points that I want to make. One of the things that's come up in terms of the vaccination requirements is there are the vaccination requirements that still include the testing option, right? So you have to show proof of vaccination, or you otherwise have to show a negative test. And that negative test now seems to be being talked about within the last week. One of the questions that I've received, and I believe other attorneys in the firm are receiving, is who pays for the test? At this point, at least I haven't seen any language that says the test has to be paid for by the employer. And that says to me that without the absence of a direction, employers will be able to say that the testing costs are to be paid for by the employee. Now, saying that with the caveat that I'm not at all making any assumption regarding the employer covered by union contracts. or maybe even another government mandate. But I'm not seeing language in these rules that ever talk about having the employers pay for the test. There's also some issues that are coming up, and I think this is going to depend on the particulars of the particular mandate as to whether the employee is entitled to paid time off. And I know that's been covered in other of our webinars. That's going to be an issue as well that may be determined by particular workplace standards and contracts and the terms of the particular mandates. But those are all things we have to be looking at. As I said, this one is just a 10,000 foot view because there were so many of these pieces coming out. The last point I want to make is the number of these mandates, I think, is significant because they reflect really at the New York State level and at the federal level now a belief that it's time for employees to be vaccinated. And that, I think, will also lead to some philosophical issues from various governmental levels in terms of, well, what happens if an employee refuses to meet these standards and there is no exemption granted? The employee leaves the job. Will the employee be entitled to unemployment? Right? I think none of us can say 100% certainty that they will not. But I think we're going to see at least a institutional bias at the state government level, which would suggest employees who resist will not be entitled to unemployment benefits. Could be wrong on that, and maybe there's varying views on that, but at least that's my view. The other thing, again, I mentioned this earlier, is the issue of, will this have a detrimental impact on your workforce? Will people come and go? I certainly am expecting some initial disruption. But at the same point, I think this will, there will be those who will be resistant. There will also be individuals who have been staying out of the workforce who are more concerned about their safety and who may be willing to come back. And Adam, with that, that's my last point for the day.
Hermes, thank you so much. While you were talking, there was actually a development as it relates to the healthcare vaccine mandate. So a question that we as attorneys had, and I know a lot of you had, and I saw one of the questions in the comments or in the Q&A, is how can you deny individuals religious accommodations under Title VII, which is what the state health vaccine mandate did. And just as of less than an hour ago, a United States District Court judge for the Northern District of New York temporarily enjoined the state's ability to enforce the vaccine mandate for healthcare workers to the extent that it requires employers to deny religious accommodations. So this is a developing issue, something you're going to hear more from us about in the coming days. But just so you know that there has been a legal challenge that was filed yesterday and now a temporary restraining order enjoining the state from requiring employers to deny religious accommodations. So that's something to keep an eye on for those of you in the healthcare industry.
Absolutely. And that's, Adam, that's also very interesting in that New York has denied religious exemptions for the measles vaccine. And that's right. We've got both federal and state courts having looked at that issue. So that clearly is something to watch for development.
Yes, absolutely. And the other thing I wanted to mention is on the who pays for the test question. You're going to have to evaluate that under various wage and hour laws, federal and state, and also consider EEOC guidance that might be relevant on that issue. But Hermes is exactly correct that there is no specific guidance requiring employers to pay for those tests. Okay, so last but not least, I mean, Katie, we only have a minute or two for you today. I know you always have so much to talk about, but feel free to go a little over. I'm sure everybody wants to hear your update. Welcome.
That's right.
Go for it.
Yes, I don't worry. This week is much shorter than it was last week with the flurry of activity. So let's look at case numbers first. We are seeing a weird plateau that's occurring with case numbers in New York. How that goes over the next few weeks will really depend on what happens in schools. There's a school that's up in the Albany area that just announced today that it's switching to all virtual because of an outbreak of COVID there. So what happens with this, graph will really determine what happens with the HERO Act, what happens with other policies that are in place in New York State. The good news is that when you look at the rate of change, as we've been talking about for the past few weeks, we are at a flat rate of change. You can see there is a slight increase from the week before in number of cases, but it's really, we're getting to the flat point. Again, I'm not confident that that will necessarily stay flat. I do think that we may see a slight increase again because of schools, but we will continue to monitor this very closely. In terms of vaccination, we've seen everything tick up 1% over the past week, which again, good news. I'm going to just briefly go over some of the vaccine mandates again. So let me lay out some of the questions that were asked in the Q&A from Hermes' presentation. So these are the federal vaccine mandates. There's the federal employee, federal contractor, the nursing home worker federal mandate. That final rule has not been put out yet. That is expected in October. OSHA's rule has not come into existence yet. This is not a requirement as of today. I will discuss OSHA in a little bit, but don't worry. I just want to make sure that everybody knows it is pending. This is not in effect as of today. State, we're looking at SUNY students have a vaccine mandate. Like the emergency regulations, we just went over those. State employees, we still haven't seen the document that says that there is a vaccine mandate in place for state employees because that was sent as an internal document to state workers and hasn't been made publicly available. But that is also pending. It was pushed out into October. For teachers and staff at schools, unvaccinated people have to be tested weekly. Again, if you have questions about that, please reach out to your bond attorney. Looking at New York City, there are a few things that you need to know. New York City had the key to New York City enforcement begin this week. That's the proof of vaccination for restaurants, indoor dining, indoor gyms, etc. The enforcement for that starts this week. All Department of Education employees in New York City need to be vaccinated. All new hires will need to be vaccinated. All city employees or contractors will need to be vaccinated or face weekly testing. And then finally, it was just announced yesterday that childcare and after school workers will also need to be vaccinated in New York City. That's a flurry I just went through, but don't worry, we're not done yet. Let's just go over really quickly some things about this OSHA announcement. This information came from our member, Tom Eron, who listened into the OSHA presentation that they gave last week. This is just some information that's helpful for you to know. There is no firm timeline about when OSHA will be issuing this emergency temporary standard. It's in the coming weeks. Let's just put it that way. We don't know when it will come out, but they announced it now in the hopes that people would begin complying with it now. It will apply to employers with 100 or more employees. It's not limited to your work site. So say, for example, you're a car dealership, you own 3 different dealerships, and in total you have 150 employees. You have 50 employees at each dealership. It applies to you. This will apply to you in that instance. Fully remote workers will not be covered according to OSHA. The role of testing remains unclear. Again, this announcement came about to encourage employers to get ahead of the emergency temporary standard. One final thing to note about OSHA. We know that there are going to be legal challenges to this. We know that there are going to be significant legal challenges to this. So stay tuned. This is going to be very much a minute by minute situation with what's happening with OSHA, as is everything that we do with COVID-19. It is minute to minute. And with that, Adam, I didn't hit it in under 2 minutes, but I did it pretty quickly.
Katie, thanks so much. And thank you to everyone who attended today. As a reminder, we'll be back here next week, next Tuesday, and look for any pop-up webinars that we are going to put on in the interim. So we look forward to seeing you. Thanks for being here. See you next week.